watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, and you shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. I think I see some folks here from the appellate practice section, so I will welcome you. We now turn to the single case on our docket today, which is DelMonico versus Traynor.
Mr. Chief Justice, and may it please the court. Can it truly be said that a false, defamatory, malicious statement made outside of court, outside of the discovery process, outside of the knowledge of the person who is being defamed?
Mr. Rogow, if you would just please keep your voice up, speak in the mic so we can hear you.
Can it truly be said that a false, defamatory, malicious statement made outside of court, outside of discovery, outside of the presence of the person who's being defamed, can it truly be said that that serves the judicial process and that serves the full and fair fact-finding process?
Are you asking us to narrow the definition of what is a judicial proceeding? Because that, to me, is one issue as to whether that's a question of law and whether, in accordance with most of the states, pretrial investigation is considered part of the judicial proceeding. So if you could first maybe start with that as to whether, because this is at a court, not in a deposition, not where there's a judge, whether it is within the scope of the absolute privilege that we adopted and have reaffirmed in Levan.
Justice Pariente, it is not within the judicial process because a judicial process countenances parties and an opportunity to be heard. And the fact that in this kind of situation, as I've described, there is no opportunity to be heard, one can say that this is not clearly within the, quote, judicial process, whatever that phrase may mean, because
But you
it has...
agree in Levan, we expressly said a defamatory statement made in a judicial proceeding is absolutely privileged, and that most defamatory, if it's defamatory, it's false, and it's usually made intentionally and with malice. So the idea that when you say, can it truly be said that defamatory statements are entitled to absolute immunity, that's what we said in Levan.
That is, and that's what I am taking on in this case. What I'm saying is that it should be a qualified privilege in the fact situation that we're talking about in a case like this.
If you're going to take the approach that action by counsel to investigate, to talk with witnesses, those types of things, one-on-one, individual kinds of things, outside the scope of the courtroom or the deposition room, is not within the judicial proceeding, then why is there any privilege at all? If you're taking that extreme approach, then why would a privilege attach at all? That's a citizen-to-citizen type of discussion.
Well, Justice Lewis, it's not quite a citizen-to-citizen discussion when the lawyer is clothed with the investigatory aspect of his representation of a client.
Well,
So
who's to say that when you say clothed with, what does he wear, a different jacket or something? I'm missing something there, because it is one person talking to another, gathering information that may at some later time come in or may not.
But
So that's why I have a difficult time trying to say or to look at a case where there is something going on that may touch upon the court proceeding, and you're saying that it's not part of the judicial process. Therefore, we talk in terms of a qualified privilege. Well, why is it privileged at all? I mean, that's the point it comes to.
Well, I think it's hard for me to say that it's not part of some kind of court proceeding, especially on the facts of this case, where there was a lawsuit pending.
I think there you're going to where probably we ought to be going in this case, and that is when you're not in front of a judge and you're not in front of a court reporter, not in front of what we quote formal court proceeding, what happens then? I think that's more of the question, rather than a situation saying, well, this doesn't cover it at all, because I think it does and needs to if we're going to preserve the adversarial system that we have.
And what I'm suggesting is, in that situation, it should be a qualified privilege, not an absolute privilege.
Well, is the privilege you're describing based upon relevance, or what's it based upon?
The privilege I'm describing is based upon whether or not the statements that are made by the lawyer serve one of the interests that the absolute privilege under Levan and the other cases stands for, whether or not it serves full and fair fact-finding. If a lawyer can lie and make misstatements that are defamatory, false, and malicious, it compromises the whole fact-finding process, which is at the heart, really, of the Levan and absolute immunity cases.
Well, you see, the problem I have, and I've been thinking about this a lot, whether it is, assuming we agree that something needs to be adjusted in Levan. I mean, we wouldn't have taken it if some of us didn't think there was some problem here. You have, if the absolute privilege says it has to be in the judicial proceeding and relevant.
Yes.
Well, obviously, this lawyer was investigating, and he was talking about the very subject matter of the lawsuit. And if he made a defamatory statement, he made it about the very subject matter. He didn't talk about, the guy had taken a trip to China and met, something totally outside of the scope. So I don't see, but if you go to qualified privilege, because again, you don't have the protection of a judge who might say, what are you talking about, or the other lawyer to moderate, then the idea would be that you would have to show the statements were made with malice.
Correct.
So that would be, so how would that work in the real life world? You filed this complaint. Right now there was a summary judgment against you because they said absolute privilege. If it was a qualified privilege, how would that work?
It would work like it does in New York Times versus Sullivan. You would have to prove that it was done maliciously. There'd be a question of what the standard of proof is. In Echeverria, the court talked about preponderance of the evidence. If the court wishes to constrict the privilege, you could have clear and convincing evidence.
Would it always be then a jury question? Because if here, Mr. Traynor says, listen, first of all, I didn't say I was prosecuting him for prostitution. I was, maybe they misunderstood that, and I was just repeating what the allegations were in the complaint. I wasn't going outside and talking about, something that wasn't there. So would a judge in that situation be able to grant a summary judgment in favor of Mr. Traynor if there's no other, evidence of malice?
The judge would not. Summary judgment would be entered in favor of the defendant, and that's why I use the New York Times.
Well, so why wouldn't this case, where's the evidence that Mr. Traynor acted with malice?
Well, in this case, it never reached that point because the Levan and the subsequent cases have held that it doesn't make any difference, no matter how malicious, no matter how false, no matter how defamatory. If it's made in the course of judicial proceedings, it is absolutely privileged.
I'm having trouble understanding here if the respect in which this case on review conflicts with Levan.
And I think you dissented, Justice Kennedy.
I did. I'm still having trouble.
I understand.
And the comments you're making here make me continue to have that trouble. It seems like there's a problem with the way Levan is set up and the inadequacy of Levan, but an inadequacy of one of our precedents doesn't mean that a subsequent decision is in express and direct conflict with it, does it?
It doesn't, except that in this case, based upon the facts of this case, when one looks at these facts and the application by the 4th DCA of Levan, it is a conflict with two aspects of Levan, really. It is, and first I think one question is, what is the course of judicial proceedings? What do we mean by that in Levan? What did Levan mean by that? The 4th DCA came to the conclusion that anything is covered. So to that extent, what I suggested in my brief on jurisdiction is that it is a conflict with the language of Levan, course of judicial proceedings, because...
But in the jurisdictional briefs, wasn't there a concession that the conduct here was in the course of the judicial proceedings?
Not in the jurisdictional brief. In the brief below, there was a footnote that did concede that in the brief below, and yet what I said in my jurisdictional brief, I pointed that out to the court, and I said, but despite that, the Fourth District Court of Appeal did address course of judicial proceedings. So there was no waiver there because that was really the heart of their decision, and they went based upon their construction that this was course of judicial proceeding. Yes, Justice Quince.
I have some sympathy with your position. I think that an allegation that the original allegation that this man may have done procured prostitutes for someone is a totally different thing from someone being prosecuted for prostitution. But my question though is where do you draw the line? Because you do have allegations of something about prostitution in the underlying case, correct?
Yes.
And so where do you draw the line when it comes to whether or not what the lawyer said was a part of his whole idea of getting discovery for this case to, represent his client zealously? I'm having a problem drawing that line because I really think that if the lawyer said what he is alleged to have said, it's truly outrageous. But where do you draw the line?
Two things. One of the other allegations is that the lawyer said to these, quote, potential witnesses that he was actually prosecuting Mr. DelMonico. So it wasn't just soliciting for prostitution in terms of business. It was an allegation that went beyond that. But the line would be drawn between the difference between making a false statement and asking a question. I mean, I think Stucchio, the case in which Judge Sharp dissented, kind of points out that kind of problem. If, for example, interviewing a witness, the lawyer says, do you have any information about whether or not Mr. DelMonico hired prostitutes for the benefit of his customers? Now, that's asking a question. That's different from making a false defamatory assertion. And that's the difference, really, that Stucchio even talks about.
But isn't that a problematical situation? Because certainly a skilled lawyer may ask the question in an affirmative statement in the nature you would of a cross-examination. Isn't it true that so-and-so procured prostitutes for so-and-so? Now, to me, if we start getting into whether it's an affirmative statement or in the question form, we're really confusing the law. It seems to me that either this is relevant to the proceedings, and I question that when saying someone is, if that's what was said. So we don't even know what was said yet.
It is true.
And so that's tough for us to decide. But to me, it's a totally different issue if someone says, he is being prosecuted for, I am prosecuting so-and-so for. Those that's a statement and the materiality of the statement as opposed to the form of being a declaratory form is the gravamen of what we're talking about, not the form, whether it's in a question or a statement. Because if we start drawing that, then we've got all kinds of problems, it seems to me.
Well, you certainly don't have to do that in this case, draw those distinctions in this case based on these allegations. But more importantly, I think that there is a difference between asking a question and stating an affirmative fact.
The problem is that Levan, and again, I agree, I thought that Levan, because it was in a courtroom, that the absolute privilege makes a lot of sense. Again, because then you know what's said, first of all, and if somebody's saying something outrageous, there's all sorts of protections, and we must remember, but Levan states, because to me a defamatory statement is never relevant because it's false, if it's true that it's defamatory. But if Levan says defamatory statements in the course of judicial proceedings are absolutely immune. So we go back around the circle. To me, if Levan encompasses everything from the beginning of the lawsuit on, then I don't see how your alternative argument was it's not relevant. And if you want to just address how we would ever make the distinction, if it relates to the subject matter, and he's investigating a case, it's relevant. So if I happen to think that Judge Warner's dissent makes a lot of sense. But if we go alternatively, that is, how do we draw that line that Justice Lewis is saying, because this is about the subject matter of the lawsuit, and Levan has a very broad statement there.
Extremely broad, even materials that happen before a lawsuit is filed. That's how Levan has been interpreted. But my focus on this, and I'm trying to keep it narrow, is on a qualified privilege in a situation where there is no opportunity to be heard. That's really got to be the key to this. I mean,
do you see that Levan totally overruled the old authority, the Hodges?
Myers versus Hodge in 1907?
Yeah.
No, I don't think it overruled. It's an interesting case to read, and it goes back through a lot of history.
It goes through, a different set of pleadings and postures and procedures, but it seems to me that there are 3 different levels of analysis that court talks about, and I wonder if those are still valid.
Well, in Myers, what you had was an allegation of treachery and deceit made in a chancery complaint. So far different. That was within the case itself. No question, that's absolutely privileged. No one would dispute that.
But it gave a procedure that courts would follow as to going through the different stages and how you get to a jury.
And when you, at least my reading of Myers versus Hodges leads me to conclude that really they're talking about a qualified privilege, and that's really a kind of source for me. I think Levan, which comes 70 years later, so almost 80 years later, has this broad language. And then Echeverria kind of follows the broad language and expands it to statutory causes of action too. Everything is protected. But again, what we're talking about here is not having an opportunity to be heard. Can something be in the course of judicial proceedings?
Well, let me ask.
Yes, Justice Labarga.
Here's what I'm concerned with. When you have absolute immunity, that's why we don't ever see many of these cases. It's a pretty high hurdle to jump over. Now, when you're talking about qualified immunity, that means there has to be factual findings made to see if it falls under that. In the family law area, where people are emotionally charged, and lawyers send out their investigators to talk to witnesses or whatever, and the investigator says things. I mean, are we going to open the floodgate in those type of cases to each time an investigator or a lawyer says something to a witness in those type of cases that there's going to be a defamation action?
I think not, Justice Labarga, if my analogy to New York Times versus Sullivan, and maybe even the clear and convincing evidence standard is applied, because that would eliminate. It's true that the absolute privilege, lawyers would say, we're not going to file a lawsuit on this. It's absolutely privileged from start or before start to finish. But the qualified privilege would serve another purpose, and that is good lawyer conduct. I mean, this court, we have 80,000 or so lawyers in Florida. The court has been very vigilant about enforcing standards. The remedy that Levan suggested, which was go to the bar, or maybe the judge could impose a sanction. Well, clearly the judge can't impose a sanction in a situation where nobody even knows about it because it's done in the dark without any opportunity
Mr. Rogow,
to be heard.
I just want to let you know you're down to about 2.5 minutes, so you're well into your rebuttal time.
And
you may continue,
but I'll take my last 22 seconds and save 2 minutes. And so I think that the suggestion that I'm making, which is a qualified privilege, really serves the important purposes, full and fair fact-finding, because if you're lying to potential witnesses, you are skewing the fact-finding process too. It is antithetical.
With this absolute immunity, the only thing that could be done, since it's a lawyer, is some kind of bar proceeding, but that would not help the person who's defamed.
Correct.
And so there's nothing the person who is defamed could actually do. I mean, this man alleges he's lost millions of dollars because of interference with his business, and so there's nothing he could do if we keep this absolute immunity the way it is.
Correct, Justice Quince, and his reputation would never be vindicated, putting aside money. And reputation is one of the competing factors here. It's reputation against full and fair fact-finding. And I'll save my last minute and a half. Thank you.
Good morning. May it please the court. I'm Rebecca Mercier Vargas. I'm here on behalf of the defendants in the trial court, attorney Roger Traynor and his law firm, Acreman Center.
Would you share with me how you find, or what's the legal theory, that when someone says that X is being prosecuted for prostitution, engaging in prostitution, or I am prosecuting X, how is that relevant to an action where they're talking about the question of whether someone has made statements about procuring them, not the prosecution aspect's what I'm going to. How is that relevant to this case?
Sure, Your Honor. Turning first to the relevance of the statement, the restatement of torts and this court's opinion in Levan apply a very broad, a relaxed relevancy standard, and as long as it bears some relation to the proceeding, it is encompassed within the absolute privilege.
What is the some relation I'm asking?
The relation is you have
a
to
prosecution, and not the subject of prostitution, but the prosecution that has a very definite meaning and statement.
Yes, Your Honor. First of all, Attorney Traynor did dispute that he denied ever saying that, but assuming it was said.
We have to assume, I guess for this, that it's the worst because you got a summary judgment, correct?
Yes, Your Honor.
So we have to take all the facts in the light most favorable to the other side, correct?
That's correct.
Okay, so taking those facts, tell me the relevance of prosecuting for
Well, the relevance is the underlying complaint involved allegations that for business reasons he was using prostitutes.
There's one thing to say, prosecuting has a criminal connotation as if you're the prosecuting attorney. This is much more serious than a civil case. So it's one thing to talk about the context of prostitution as it relates to the pleading, but it's quite another to affirmatively assert that I am prosecuting this man for procuring prostitutes. I mean, that's a statement. That's not an investigatory. He's more or less inserting himself into the factual pattern.
Well, Your Honor, the First District's decision in Hope held that the broad standard of relevancy encompasses just the fact that you might be alleging criminal conduct does not take it outside the scope of the privilege. And keep in mind, the underlying lawsuit that was being investigated here involved prostitution. The allegation in the underlying Crespo complaint was that he had been imputed criminal conduct because he was engaging in prostitution. So this lawsuit involved prostitution. If this lawsuit were a typical business dispute, then it might be outside.
Was he the prosecutor?
He was not the prosecutor, Your Honor. He was not the prosecutor.
Was there
However,
ever a prosecution?
no, there
So
was not a
clearly there was
prosecution. No,
How
but,
far does this go?
well, Your Honor, it's a very relaxed standard because attorneys need to be free. I think this
Well,
is a
that's no
perfect
standard at all. I
Well,
mean,
this-
what is the standard? That's what I'm asking. A very relaxed standard. I mean, that to me could be the whole world. What is the standard?
Well, the standard is it needs to bear some relation to the proceeding. And in this case, it did bear some
The
relation.
prosecution bears a relationship to this proceeding.
Yes, Your Honor, because
Okay.
it's within, you have to be able to speak freely. Otherwise, keep in mind
Well,
that
then
this.
that's what you're saying. I mean, if you're taking it only because the statement is made without regard to the content of the statement, then anything goes. You have to look to the content of the alleged statement, it seems to me, do you not?
Well, the content is prostitution.
No, I'm
I think-
asking about prosecution for prostitute. We wouldn't be here if
Well-
this were just a discussion of prostitution, would we?
Well, the underlying lawsuit involved criminal allegations, and
That somebody was prosecuted for it?
he said it imputed criminal conduct to him.
That someone was prosecuted. I mean, you keep avoiding, please answer it.
No,
I mean, we need to address this head on.
Well, it doesn't involve prosecution, but I think it's well within the broad penumbra of when you're speaking about prostitution. I think in this case, there very well could have been a misunderstanding when an attorney says, I'm part of the team, my client has been sued for a lot of money.
Isn't that what then, whether it was intentionally made and what statement, you'd have to find out what the statement was?
Well, I think that just points to the fact if you adopted that standard, there'd be a jury question in every single case. An attorney would never be able to ask a potentially controversial question. There would always be a jury resolution of whether the attorney's statement was closely related to the subject of the lawsuit.
Let me ask you this. Let's assume you have a couple of parties who are in contract with each other, two companies.
Right.
And one of the attorneys for one of the companies goes to depose the other's major customer and makes an assertion that the opposing party engages in giving bribes in some fashion, and to the detriment of the opposing party. But yet it bears in some degree on business practices of the opposing party, but yet it's totally false. Is that actionable?
Well, what was the subject of the lawsuit? Did it have anything to do with that?
Yes.
Well, if the subject of the lawsuit had
But not
something
bribes. Had nothing to do with bribes. But
Well, then that would be unrelated.
It had to do with the business practices of each side, and there's a breach of contract action.
Correct. I think in that case, under those facts, when it's a breach of contract action completely unrelated to bribery or other criminal conduct, that might be outside the scope of the privilege. But that's not this case. In this case, we have a witness who's speaking to purchasing agents, asking them if they have any information about prostitution.
Let me ask you about one of the other allegations, which is that not only did he ask an ex-wife or ex-girlfriend or something about prostitution, but threatened her with prosecution if she had some knowledge and wasn't willing to give up that knowledge. And you think that kind of statement, assuming that it's true, is also absolutely privileged?
Well, that statement's actually not found in the complaint. There are some allegations within the factual matter. They amended their complaint to make other allegations, but that was not something that is specifically included in the complaint that's at issue in this case. But I think it's within the broad scope of what the attorney, when an attorney is trying to speak to a potential witness and asking for information.
Them. What I'm getting at is that this was, as I read it, a threat to the witness to try to make the witness make some statement about this man's involvement in prostitution. And you think an allegation like that, assuming there's an allegation like that, is absolutely privileged also?
Well, no, under Levan carved out as possible remedies to deter misconduct the possibility of criminal sanction. So certainly you can't violate the law, you can't suborn perjury, you could still be subject to criminal prosecution. And keep in mind this, there is a pending litigation here. You're also subject to the contempt power of the court. You're subject to contempt, which compensatory fines. You're also subject to... Which is
always very interesting, that the court can sort of vindicate its authority here. But what happens to the person that is being defamed? What we have here is a situation that person can never be made whole. He says he lost millions of dollars. He says he lost all these business contacts because of this information. And if this absolute privilege goes to all of this information, which was not true at all, assuming it's not true at all, assuming all of these statements were in fact made, it's just bothersome to me that the actual person who's defamed has no remedy.
Well, Your Honor, that's exactly the policy debate that this court engaged in Levan and also more recently in Echeverria. There is a risk that some individuals will have defamatory statements made and their individual reputation might be damaged, and some damages might go uncompensated. That is a risk. However, the benefit to the court system in general and the ability of parties and witnesses to gather information and freely and fully litigate issues in the initial lawsuit outweighs that risk.
Let me ask you this, because I'm still trying to figure out where does it end and where does it start. And Judge Warner, in her dissent, she noted, says, although there is certainly nothing wrong with an attorney conducting extrajudicial investigations, the conduct of such investigation is removed from the judicial process and is not a function that rests uniquely within the duties of an advocate. She seems to be saying that once you go outside what is typically permitted under our rules of discovery, you're stepping into a different zone.
Sure. I think that is what Judge Warner is saying. She's saying if it's not a formal discovery request, do it at your own risk. If you're a witness, don't speak to attorneys without a subpoena. If you're an attorney, don't speak to a witness without subpoenaing them first, or calling the other side, divulging your work product and divulging your trial strategy and saying, hi, opposing counsel, I'd like to speak to this witness about this issue. What time is good for you?
But that and also what we see commonly in high-profile cases today, every single day after the end of the testimony, at the end of the trial, the lawyers step outside in the front steps of the courthouse and provide all these extrajudicial interpretation of the evidence to the media. Well, and would that fall under the
no, that would not,
absolute
because
immunity?
That would. I apologize, Your Honor, but that would be a broad publication beyond the scope of the qualified privilege. That would be a statement to the press. Is not someone who's interested in the party. Keep in mind, these were witnesses. If you look at their affidavits, each of them was deposed as a fact witness in this suit. In the motion for summary judgment hearing, the plaintiff's own counsel said defendant was, quote, interviewing witnesses, end quote. These were not members of his softball team. These were not neighbors. These were people with crucial factual information that was necessary to explore.
Well, how about if instead of talking to this one person, that they publish, this happens someplace in South Florida, I take it, in Fort Lauderdale or some area down there?
Yeah, the underlying facts, yes, right.
These issues. So I take out an ad in the Sun Sentinel saying that X is being prosecuted for prostitution, running, or whatever the name of the statute is. That I am prosecuting for that. If you have any information, contact so-and-so.
Well, statements in the press are beyond the scope of the privilege because they're not to parties that are related to the lawsuit.
Well, this is, it's a publication, it's an investigation. It's trying to gather information. Is that, so you're saying that's not?
No, we've cited out-of-state cases that have made that distinction. Once you're talking to people who have no interest in the litigation, who have no information to give in the litigation, that's beyond the scope of the privilege.
What draws the line as to, you know, I say that person may have knowledge. Does that close the door on the privilege issue?
They haven't challenged that the witnesses here have knowledge. They were deposed as fact witnesses in the case.
Well,
There's no
because
dispute.
somebody is deposed doesn't mean they have any knowledge of whether the guy's engaged in prostitution.
If this court were to
How many
change...
depositions do we take in a case that people really don't know anything?
Well, if you change the rule in Levan, you'll be taking a whole lot more depositions because no witnesses will ever talk to an attorney without
Well,
a
I think you're
subpoena.
bringing on this gloom and doom. I'm
Well-
sorry, I don't subscribe to that. If you have a fair principle of law, that the whole world's going to come to an end.
Well,
So I think what we need to do is to address a circumstance, not Levan, because this is not under the supervision of the court, but what happens when you go out to individual people in the community and start making statements. I mean, that's what we have to deal with.
Right. Well, they're not just individual people. They're people who are witnesses who have information about the case. And if you think back to when you
What
practiced...
establishes that in this record, that they absolutely have
They're on
knowledge?
affidavits. They were witnesses in the case, and that they, one of the witnesses, Pietri, was a critical damages witness, and according to their complaint, he's the person who changed businesses as a result of
Did he
these
have knowledge
statements.
of prostitution activities?
Well, I don't know if he actually had knowledge, but
Well, he's
often
not a
attorneys
witness as
don't
to
know.
prostitution.
Yeah, how do you know that until you speak informally to the
Well,
witnesses?
that's what I'm saying. How do you know until you talk to somebody whether they're a witness or not?
Well, and that, I think, demonstrates why you want to allow attorneys to speak freely with potential witnesses. So
Well, I have
neither-
no problem with attorneys speaking truthfully with people. It seems as though we have a whole generation of lawyers now that don't give a hoot about whether truth is transmitted or not. And that may be an unfortunate statement, but that's what we see. And sometimes things change during the history of a profession, and things can happen. And the question is, do our rules of law keep up with what's actually going on the street?
Well, Your Honor, as the Supreme Court, you certainly have the ultimate responsibility to discipline attorneys, and it is your ability to impose bar sanctions and to police attorneys.
So a phantom remedy is sufficient.
Well, a
That's the
bar
truth of the
discipline
matter. Let's
proceeding.
be honest here. We do not supervise our lawyers to that extent, and that's a phantom relief. To make that statement that we can catch everybody that makes statements to somebody out in the public.
Well, I think it's a public policy decision that attorneys are
Right.
professionals who could lose their license if they're making false statements, if they're making,
The
if
question
they're
is, our
hurting.
principles of law need to be in sync with what the real world is, and not some fantasy world. You agree with that?
Well, I agree that that's true, that it needs to be in sync
Ms.
with the
It
Mercier-
may be that Levan still applies.
Okay. Just trying to get a question here. There seems to be members of the court that are concerned that when you are talking about being prosecuted for prostitution, that's not relevant to the subject matter. And then that would involve, if that's the case, if you relax Levan, because to me, Levan says anything defamatory and the act of investigation, you don't really look too closely at the content. Isn't it better to go, if you had as a lawyer thinking about defending against a lawyer's conduct, to have the qualified privilege for extrajudicial proceedings? Because again, you don't have in a deposition you have a record, so you know what was said. We don't have to say, well, I don't know if he said prosecuted or not. You're before a judge, you have a record. Through discovery, interrogatories, you have a record. Here, you don't have a record, so now it's a swearing match. And it seems to me the policy is better served by the person who is alleging something having to say that it was done, it's false, and it was done with malice, which is, and I heard Mr. Rogow say, well, maybe it's a clear and convincing standard, than trying to figure out, for the jury to figure out, well, did he say prosecuted for prostitution, or did he say we're investigating an allegations of prostitution, and leaving that ultimate question of the exact substance of the statement to a jury. To me, I guess by saying it, I think that's why the answer is the policy in terms of free speech versus defaming somebody. The key is that you don't have a record here, and we're going to have a swearing match, which is going to, and if we have to say whether it's relevant, then in cases, family law, they'll just say anything they want to say, and it will have to go to a jury. So why isn't a qualified immunity better for protecting lawyers? Because most lawyers were assuming, well, maybe they'll make a statement that they thought were, was whatever it was, but they're not making with malice if they're representing their client.
Well, I think the problem with that, Your Honor, is if there's a qualified immunity, there'll be a jury question in every single case. And keep in mind, we're not just talking about attorneys. We're also talking about witnesses with valuable information that we want to be free to come forward and speak freely, even if the evidence that they have is controversial. The same thing for the attorneys, that you need to have attorneys.
Why they can't speak freely. I understand about pretrial investigation, but there are depositions. As you said, all these witnesses said they were deposed.
That's right.
So they'll feel free to give a deposition. And I think, again, the idea of something being said with malice is something that is amenable to some region. You just can't infer it. You'd have to show some reason that Mr. Traynor would have a desire to injure the reputation of the person who is the plaintiff or the defendant in the lawsuit, however it went originally.
Right. Well, I'd like to point to the court's decision in Echeverria also, which was more recent than Levan, where you balanced the same policy interest and found that the right to free information outweighed the risk of possible defamatory conduct. And in Echeverria, the actual tortious statements in that case were letters sent before a lawsuit had even been filed. And so while Justice Perianti, you and Justice Wells both wrote concurrences questioning whether that was really within the course of the proceeding, the question was because of the timing. There was never a question because those letters weren't part of the formal court file, that they could not be considered
part of the proceeding.
Have a
letter which is capable, I don't know if it's a pretrial suit, but you've got something that is capable of someone evaluating, and again, whether it's the judge or the other side, to be able to, as Mr. Rogow said, have notice and be able to take whatever was in a complaint, which is in itself pretty outrageous stuff, and be able to go, wait a second, they're saying this. There's no evidence that he ever supplied prostitutes to his customers. The subject matter itself is pretty racy. So,
right, and that just explains that when the subject matter is he uses prostitutes to get business, it's very difficult to speak to anyone about that without mentioning the word prostitution. And there is a possibility.
The offending word is not prostitution, as offensive as that may sound. It's prosecuting.
I understand, Your Honor, that the word is prosecuting, but I think that that's still related to the underlying criminal conduct of alleged prosecuting. Yes, Your Honor, because it's a broad, it just has to bear some relation.
Maybe I'm missing something here.
Sure.
But isn't the term prosecute frequently used with respect to civil suits?
We're
prosecuting a suit.
I could easily see that happening here, where it was a miscommunication, where he said, we're bringing a lawsuit, we're prosecuting a lawsuit.
They're defending. They're not prosecuting a suit.
I think that you keep in mind that he's speaking to a layperson.
Were they defending the case?
They were defending a lawsuit, but still, I could see it happen. With that, I'd also like this court.
But I think he said he didn't say it, didn't he?
I apologize.
Didn't he say he didn't say it?
He denied saying it, Your Honor.
All right. So it's a factual issue, is it not?
It is a factual issue, as it would be in any case, and that's why we asked this court to reaffirm its holding in Levan. There's no reason to change the law in this area.
I guess he could say he was prosecuting a defense. That's one of the oxymorons.
I guess, Your Honor, but it just points to how this is really, it becomes a factual question. An attorney needs to be free to speak to a witness in the informal setting without fear of both the attorney and the witness having their own personal liability on the line and being afraid to come forward with valuable information, and for attorneys to ask the hard questions that are necessary to actively defend their clients. With that, I'd ask this court to please revisit its decision to exercise jurisdiction in this case, and if not, to affirm the decision of the 4th District. Thank you very much.
Mr. Rogow, I will give you an extra minute.
Thank you, Justice Kennedy. Absolute immunity is actually a very rare thing in our judicial system and in our legislative system. The Speech and Debate Clause, of course, protects members of Congress from things that are said on the floor of Congress. Florida doesn't even have a Speech and Debate Clause provision in the Florida Constitution, although it did in the 1865 Constitution. So we're looking at something very, very unique when you talk about absolute immunity. And
If we're speaking of the principle, though, isn't counsel correct that we should not have to litigate a case litigation multiple times for who said what during the underlying litigation? I mean, that there's no end to this.
Well, I think there is an end. I mean, you are right, Justice Lewis, but that's why I think that the balance that I'm suggesting, the qualified immunity, you know, when you talk about the First Amendment and the right to comment about public officials, it's a qualified immunity that comes into play there, and that's what we're talking about here. And these cases would not go to trial if you use the same standard. If the evidence turns out that there's no malice, then the case is over. But what are we balancing here? You heard the argument, the attorney need to be free. Well, you know, that is not completely so. We certainly don't subscribe to attorneys need to be free. There are limitations. And on the other side is the individual's right to reputation, which is about as high an interest as one can have, even beyond the notion of damages. And so the risk that would be avoided would all be addressed by a qualified immunity kind of situation. There is a balancing, of course, and what I'm suggesting is an effort to strike the balance that serves the fact-finding interest. Judge Warner was very clear about that. This could be antithetical to the fact-finding interest when you have lawyers lying to potential witnesses. Levan is not a license to lie.
Is a charge or an accusation of criminal behavior sufficient to establish, at least preliminarily, malice?
It would be per se.
That's what I thought. So, so then all you have to do is in these complaints is make some kind of statement, allegation that someone implied criminal conduct, and you're going to have every witness who's talked with. We're going to have another lawsuit on what was said and what was not said then.
And then there would have to be, it could end on summary judgment if the court found that there was no malice in terms of how it was said.
If the allegation is made, you cross the threshold, you're at least going to have to defend the lawsuit.
Yes, yes. We respectfully request that the court reverse the decision below and address the issues that we presented. Thank you.
We thank you both for your argument. The only case on today's docket, so the court will now be adjourned.
All right.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.